He was pulled over for unpaid tolls. Not drugs, not a weapon, not a violent crime, unpaid tolls. He was calm, cooperative, and did nothing that any reasonable person would describe as threatening. And 2 minutes later, he was dead. At the same time, in a quiet suburb miles away, a 73-year-old grandmother who had never received so much as a speeding ticket in 40 years was woken by the sound of her front door splintering inward. Flashbang grenades detonated in her hallway as armed federal agents tore her home apart for 6 hours, finding nothing. 2 different people, 2 different tragedies. But they were both erased by the same legal machinery. In both cases, the court said the officers did nothing wrong, not because their actions were perfect, but because the law allowed the courts to put on blinders. In the case of the shooting, the court only looked at the final 2 seconds. In the case of the raid, the court only looked at a single piece of paper. But everything changed on the same day. 9 justices in Washington, D.C. looked at these rules that protected state violence from scrutiny, and arrived at the exact same conclusion: 9-0. No dissents, no ideological splits. Every justice agreed that the rules protecting these actions were unconstitutional, and they are gone. These rulings are Barnes v. Felix and Chen v. United States. If you think they only matter to attorneys or those specific families, you have not yet understood what the Supreme Court actually said and what it means for every single person in this country who can be pulled over on a road or has a front door, which is every single person watching this video right now. Welcome to our channel. This space exists to bring you rulings like this the moment they matter, not after the fact. Subscribe right now and hit that notification bell, because the next decision that affects your rights won't announce itself. It will just change what's legal while you're going about your day. 2 seconds and a piece of paper. Hit subscribe. Now let's talk about what 9 justices just told every court in America. To understand why these rulings are historic, you first need to understand the rules they destroyed. When a police officer uses deadly force or the government wants to search your home, the Fourth Amendment requires those actions to be objectively reasonable. This is not new law. In the 1989 case Graham v. Connor, the Supreme Court established that courts must evaluate whether an officer's actions were reasonable from the perspective of a reasonable officer on the scene, given the totality of the circumstances. Look at the whole picture, the full context, every fact and decision leading up to the moment force was used or a home was entered. That is the constitutional standard. But something started happening in certain federal courts, something quiet, something that most Americans never noticed until they ran headfirst into it. Certain courts started applying a different rule for shootings called the moment of threat doctrine. Under this rule, a court could only look at one specific window of time, not the buildup, not the decisions that created the danger, only the precise moment the officer perceived a threat and pulled the trigger. Everything before that, legally irrelevant. Simultaneously, other courts were applying what scholars called the good faith exception on steroids for search warrants. Under this framework, if an officer held a warrant with a judge's signature, the investigation that produced that warrant became invisible. The sloppy investigation, the fake tips, the reckless claims, all of it was wiped clean by the paper. The warrant became a time machine that erased constitutional error. Here's the critical problem the Supreme Court finally addressed. If you can only evaluate the final 2 seconds of a shooting, or only the piece of paper for a search, then almost any government action can be made to look reasonable. You could create the danger yourself or lie to get a signature, and the law would shield you because of the blinders the courts were wearing. It was a formula for immunity, not a constitutional standard. By 2025, these doctrines had created a split in the country. Your rights literally change depending on which state line you crossed. The Supreme Court exists to resolve these splits, and they did so with a thunderous, unanimous voice. Let's look at the facts of the cases that forced this change. Ashton Barnes was 24 years old. He was stopped in Houston for a toll violation. The video is clear, he was cooperative, but the officer made a series of tactical decisions that led him to jump onto the door of Barnes's moving car. At that moment, the officer feared for his life and fired. Under the old rule, because the officer was in danger in those final 2 seconds, the shooting was legal. The court refused to look at why the officer was on the car in the first place. Then there is Margaret Chen, a retired schoolteacher in Colorado. Agent David Reeves received a tip from an informant who had never even been inside Chen's home. The agent didn't conduct surveillance, didn't check property records, and didn't verify the tip. He drafted a boilerplate affidavit, got a signature, and executed a no-knock raid with flashbangs on a 73-year-old woman with a heart condition. They found nothing, but the lower court said the warrant was a shield. The recklessness didn't matter because they had a signature. When these cases reached the Supreme Court, the justices didn't just tweak the law, they reaffirmed the core of the Fourth Amendment. Justice Neil Gorsuch, writing for a unanimous court in the Chen case, noted that the good faith exception was never intended to swallow the warrant requirement. It cannot be used to insulate from review the very process by which warrants are obtained. In the Barnes case, the court was equally clear. You cannot judge a shooting by looking only at the moment of threat, while ignoring the moment of escalation. The era of chronological blinders is over. Now, here is what this means for you in practical terms. If you are ever in a situation where your home is searched or you are stopped by police, the full story can now be told in a federal courtroom. The investigation, the diligence, the proportionality of force, all of it is now on the table. But understand this, the Supreme Court gave us a new framework, not a guaranteed outcome. The totality of the circumstances is now the universal standard, but it still requires courts to evaluate facts. Officers still have the qualified immunity defense, and justice still depends on the strength of the evidence. These rulings opened a door. They didn't walk through it for us. What the court did was stop the practice of courts pretending the lead-up to a tragedy doesn't exist. This is a meaningful, concrete, nationwide expansion of Fourth Amendment protection. It happened because people like Janice Barnes and Margaret Chen refused to accept that the last 2 seconds or a single checkbox on a form was all their lives were worth. So where do we go from here? The shield is now smaller. In the circuits that were using these rules, Maryland, Virginia, Texas, Louisiana, Florida, and others, the impact is immediate. If you live in these states, the legal landscape just shifted beneath your feet. But the Supreme Court also left questions unanswered, particularly regarding mass surveillance and digital warrants. They signaled that these are the next battles. This ruling is a foundation, but the House of Accountability is still being built. The most important thing you can take away today is this. Your behavior across the entire interaction with law enforcement is now the legal record that matters. Because the courts are finally allowed to look at the whole picture, you must make sure that picture is one of clarity and cooperation, even when the state is in the wrong. Stay calm, speak clearly, document everything. The law now requires the court to listen to the beginning of the story, not just the end. If this is the kind of breakdown you want, the kind that explains your rights before they are tested, not after, make sure you are subscribed. We track every major ruling from the High Court to ensure you aren't just watching history but understanding how it protects you. The Constitution is a living document, but it only lives if we know what it says. 9 justices just gave the Fourth Amendment its teeth back. Let's make sure we know how to use them. The impact of these 2 cases combined cannot be overstated. By merging the moment of threat abolition with the warrant shield destruction, the Supreme Court has essentially told law enforcement, we are watching the whole process now. For decades, the legal system functioned like a movie that only allowed the jury to see the final scene. If the final scene showed a struggle, the officer was cleared. Now the law requires the court to play the entire movie from the opening credits. They want to see the investigation. They want to see the stop. They want to see the escalation. They want to see if the government followed its own rules before it broke down yours. For the Barnes family, this means a chance at a trial that actually considers the officer's choices. For Margaret Chen, it means her lawsuit for the destruction of her home can finally proceed based on the sloppy work that led to the raid. And for you, it means that the formula for immunity has been replaced by a standard of reasonableness. Reasonable people look at the whole story. Now, for the first time in a generation, the law does too. The split between the states has been mended. Whether you are in New York or Texas, the Fourth Amendment should now mean the same thing. This was a rare moment of total unity from a court that is often deeply divided. When the most conservative justices and the most progressive justices agree 9-0, the message to the lower courts is, do not try to find a loophole. The blinders are off. This channel is dedicated to these moments of clarity. We live in a time where legal jargon is used to hide the truth. Our goal is to strip that jargon away and show you the bones of your rights. Because when you understand the law, you hold the power. Subscribe to stay informed, stay protected, and stay ahead of the next major shift in our legal system. Your rights are the only thing standing between you and the raw power of the state. Know them, use them, and never let the 2 seconds be the only thing that counts.